Good morning and a very warm welcome to the CICV Forum's 9th webinar. Today's topic is Organisational Restructuring and Redundancy. My name is Fiona Harper. I am the Director of Employment and Skills for the Electrical Contractors Association of Scotland, better known as Select. I'm joined today by Vaughan Hart, the Managing Director of the Scottish Building Federation, and Pete Walker, the Director of Health, Safety and Training for the British Constructional Steelwork Association, BCSA. While I have your attention, just let me explain a little bit about what the CICV Forum is. The Forum is a collective of 25 full members representing professional and trades bodies. It benefits from the output of more than 37 organisations involving more than 100 people who contribute their expertise to 4 subgroups which give focus to important sector issues which are then fed into the recovery plan developed by the Scottish Government and the Scottish Construction Leadership Forum. The 4 subgroups include skills and workforce, transformation, pipeline and commercial, and supply chain resilience and capacity. In addition, we have recently formed a Brexit subgroup, and all the subgroups in the main forum are supported by the communication subgroup. Between us, we represent 35,000 operatives and 8,000 businesses. The forum has only been in existence since the end of March. It came together as a response to COVID-19 and the lockdown. By pooling our expertise and knowledge, the Forum represents the interests of Scotland's diverse construction supply chain with one consistent voice. Our priorities include lobbying the Scottish Government to influence policy and push for positive action, and also to give focus to important sector issues, including commercial, employment, planning for the future, skills and health and safety. We have a busy website packed with guidance for our respective members and the wider industry. So please take a few moments to have a look at it, and you are more than welcome to top and tail any of the guidance for use in your own organisations and companies. Vaughan is the presenter today. He will set the scene, help us to understand what a fair dismissal looks like, explain the subtle differences between organisational change and redundancy, and finally, he will lead us through the redundancy process. Before I hand over to Vaughan, there is just one piece of housekeeping to bring to your attention. Vaughan will lead us through the presentation in full, and the panel will take questions at the end. If you would like to ask a question, please type it into the Q&A and we will pick it up. So that's all from me for now, and it's over to Vaughan.
Good morning, everyone, and many thanks, Fiona. But before I kick off, just to let everyone know that the session will last around about 30 minutes from myself. And what I plan to do is some slides I'll go through greater detail than others, but most I will not go through them verbatim. Lastly, I'm keen that the presentation doesn't come across as negative or pessimistic. However, I think it's still important that we are not only aware of what we need to do, that we're actually getting to a stage where we're prepared to take any action that is needed depending on the economic circumstances that we're going to face moving forward. So today, what I'm going to talk about is, again, going through these key considerations, the current economic impact and the likelihood of organisational change. And we've seen since we've allowed to come back to work in June, July, that we're already seeing some indications. We're then going to look at the definition of dismissal. What does that actually mean? And then I'm going to talk about redundancy versus organisational structure and look at if there's any real differences and how we apply the process, which then leads us to the next step. We're then going to look at the understanding the fair reasons for dismissal and then really what you need to do to move forward. But before we do that and go on, I think what we need to do is go on to the next slide and look back at where we were back probably 2008, 2010. And I think those of us that were around then and those of us that were working in the industry, what we saw is a greater need than ever to reorganize the businesses due to the volume of work and possibly a greater diversification model that we had. In Scotland, we did see, and I've been probably quite conservative here, we're saying here that we saw between 30 and 40,000 jobs were lost directly within the construction and related industries. Some people actually reporting that there are actually more than that. What we did as professionals, and we saw this and we evidenced this, is employers often waited effectively to the last minute to reorganize and reduce the size of their business. And this did, and we did see, sadly, that did in some circumstances result in insolvency of some businesses. That in some cases need not have happened if the businesses were better prepared. However, they weren't, and this is what we probably need to learn to moving forward. In addition to that, what we also saw is because of the last minute approach, we did see a failure to properly consult or select properly. And this did lead to a significant increase of unfair dismissal claims, which most of us across the Federation saw, which in a way you could argue, and in hindsight, it's a great thing, if the process was applied properly, that did not need to happen. Also, and I think it's really, really important to understand that when you're dealing with a situation like this, if you are reducing your business when there is an economic recession, the ability for someone to mitigate their loss by going to get another job if they've been made redundant from your business is going to be slightly more difficult. And as a result of that, if they can't get a job, you've unfairly dismissed them, then the remedy in an employment tribunal could be far higher to actually compensate them for the ongoing loss. And that could be between 26 and 52 weeks of their pay in extra compensation. So I think we need to be aware of that. And what we did see the last time is we did see cases in excess of £10,000. And again, I'm being very conservative there, somewhat a lot more than that, just because processes weren't being followed. So if we move on to where we are now on the next slide, autumn 2020 onwards, and again, what we've seen already from obviously May and June is we did predict that there would be a potential need to review businesses due to the uncertain future, delay, cancellation and reduction of work to be done. And we are evidencing that in some areas. In some areas, we have seen an automatic sustained reduction of work. However, I'm going to be positive here. In some areas, we have seen huge and greater levels of buoyancy. You could argue, is that because people didn't go on holiday, and as a result of not going on holiday, they're using their excess money? If they have any excess money within the domestic marketplace, they're using that on home improvements, renovations, or other work. So again, that has potentially supported levels of buoyancy moving forward, in addition to the fact that there were jobs that were assisted as a result of the pandemic, and that those jobs needed to be completed. So again, are we seeing false figures? And therefore, when is that, or is that going to change? I think across the UK, not just in Scotland, we've got to compare, how we in Scotland fit in with the rest of the UK. We are generally witnessing an economic decline, despite the immediate upsurge, as I put here, as a result of the pandemic. And I think, notwithstanding the pandemic, there is, and potentially a sustained reduction in confidence in the market as a result of Brexit. And I think we need to take that into consideration. So what I'm going to do, this next slide looks at the definition of dismissal. What is dismissal? How does it happen? And I think if we understand that in context, I think then some of the other parts of the presentation will actually make more sense. And again, I apologize to those people that are either looking now or looking into the future into this presentation that know this already. But first of all, dismissal is where the employer, and this is the most obvious one, is where you, the employer, terminate the contract of employment of the employee with or without notice. Second one, and I think sometimes we underestimate this one, is this is where the employee decides to resign from your employee with or without notice because of the employer's conduct. Okay, and we can come back to that one later. But again, I think that's a very, very important definition that employers, some are aware, some aren't aware. And the last one is the ending of a fixed term contract, where you've employed worker or workers to do a specific job for a time scale, and that job comes to an end, and therefore that's a natural reason for dismissal. And again, I'm using the word dismissal. Dismissal sounds very negative, but it's a very legal word, and that's why we're using it. So again, we then move on to the next slide, and we're looking at under, and again, to bore everybody here, we're looking at Section 98 of the Employment Rights Act, and there are in law 5 fair reasons for dismissal. So the first one is an employee is either unable physically or mentally to do the job. And this is the definition of that if we have an employee that's been off for a substantive period of time due to ill health and there is little likelihood of them coming back, then you would potentially look at termination under the grounds of capability. Or another reason could be they don't have the qualification or the skill to do the job, and therefore that would be another justifiable reason for dismissal. The next one, which is probably the most common, is conduct. Employee's behavior, the employee has been naughty, and as a result of that, that justifies the employer to dismiss after following a process under the reason of conduct. The next one, and we'll be focusing on this one, is the closure of business, closure of the site, diminishing need for the work to be done, and that's why we've got the label here, redundancy. Next one, which is an interesting one, is an employee needs to have a driving license to do their job and they lose their driving license. So therefore, there is a statutory obligation that they have that, and that would be a fair reason for the employer to dismiss the employee for that reason. Or you have a trade such as a general practitioner or a solicitor, you need that qualification, or you need that kind of ratification to do your job. If you don't have that, that would be another reason for dismissal. And the last one, which again we're going to look at in more detail, is, and it's a typical, I suppose, catch-all reason, is an any other substantial business reason, okay? And therefore, this is where we'll be looking at reorganizational restructuring, or effectively it could be frustration of a contract due to criminal conviction. The two that we will be looking at today is redundancy and other substantial business reason. The last thing I'm going to say on this slide, and I think it's important, sorry, the last thing here is when you are dismissing someone, when you write to an employee and you are saying you are dismissed, you have to, and it is reasonable to do this, is you have to tell them why, and you have to give them the reason for the dismissal. And in my experience, and this is an experience thing here, is my advice is you must get it right, because if you get it wrong and they take you to an employment tribunal and the reason isn't what you said, and the tribunal finds out that it was actually for another reason, then the dismissal could be found to be unfair, okay? Moving on then to the next slide. Bear in mind as well, before I talk about this slide, the presentation here is guidance. It does not substantiate advice. So again, I'm going to say this probably 3 or 4 times here through the presentation, is if you are unsure of anything, please seek some professional support. And I can't iterate that enough, okay? So talking about the 3 R's here. The first one is reorganization, and COVID is probably a great example of explaining this. We've come back to work. Generally, we're not working in the same way as we did prior to March of this year. And what we're often seeing or witnessing is employees doing different jobs. We're seeing people do things in a different way. And generally, people have or are having different roles and responsibilities. So in a way, what we're naturally seeing through most organizations at the moment is that they've already applied a level of reorganization, okay? And that's either because they are not working to full capacity, that's because perhaps they have some people still off from COVID or COVID-related absence, or as a result of the furlough process because there's not enough work. So we're seeing that. And therefore, that will then lead us into, well, are we going to change the way in which the business runs in the future? And I think that's a question that we need to ask ourselves, and lots of businesses doing that at the moment, saying, well, it's actually, we've had 3 people off, but we're still doing the job really, really well, and we're still getting the work done. So do we need to revert back to where we were pre-March of this year? So I think that's something to be really to take into consideration. The next one then, as a result, is perhaps looking at restructuring the business, okay? And we saw this, those of us around in the 80s and the 90s, and I think the best thing I can explain here is we saw this through the privatization of lots of these public sector organizations like electricity, gas. We saw it through British Telecom. That what we did is we saw through that period a natural flattening of organizational structures. We saw the stripping out of supervisory positions and bureaucratic structures. And the reason that was done, it was done to the fact of businesses were becoming more efficient in their way in which they were operating. In addition to that, they wanted to become more financially efficient, and therefore said that actually I didn't need 4 or 5 different supervisory layers, 1 or 2 would do. And that was due to, again, an economically driven process. And personally and professionally, I think lots of businesses or the larger business will look at this moving forward into the future, perhaps because of tax implications or just general, in order to make ends meet and to make sure a profit is made. So we'll see that. The last one here, which we'll talk about again in a wee bit, is obviously redundancy, and that's the last one. This is when we're looking at saying that we are going to reduce headcount as a result of a reduction in work or the need for work to be done. So if we move on here. So first of all, if we're looking at reorganization restructuring, and I think it's important to note here that this is not legal terminology. We will generally not find this we might see this in common law principles in case law, but generally we will not see it within an Act of Parliament, reorganization and restructuring. So there's you'll not be surprised to see that there's no exact definition of this. And really, these usually refer to changes within the organizational structure or the roles within the organization that we've spoken about already. What I think is also important to say as well is this may or may not involve a loss of headcount. And this is where this area becomes quite grey in HR and legal terminology here, because there's a famous case called Pacman versus Fortune in 2012, and Pacman Lucas Associates, they had a reduction in the level of work that they had to be done. So what they did, in addition to that, they wanted to create a level of efficiency. So they brought in a bookkeeping software into the business, and they actually said to Mrs. Fouchon that you still got a job. However, we want you to put less hours in because the computer system there, the technological revolution will actually negate the need to work so many hours. So what they did is they dismissed her through organizational restructuring rather than redundancy. And to cut a very, very long story short, the Employment Appeal Tribunal overturned the original decision and said that no, it was in fact a redundancy, because there doesn't necessarily need to be a reduction in headcount to say that there was a redundancy. Now, it's just really to say if you are applying an organizational restructuring, it may give us a level of benefit, but at the end of the day, the compensation would be very, very similar. So again, I'm going to say, if you're in any doubt, please speak to an HR or legal professional. Moving on to the next slide. That with reorganization and restructuring, it's arguable that there is not a specific defined process. I would argue that the consultation is still necessary, and you would apply a similar process that you would to redundancy. And if the result is anticipated to end in termination due to a proposed change to the contract, I would also argue that the employee would be due notice and basic award payments would be applicable. And what I'm using the legal terminology of basic award, we would, in layman's term, basic award is your redundancy pay, and that's how that's calculated. So you would argue that they would be payable even if you organized and there was a dismissal as a result of the reorganization. Yeah. And again, although argued not a requisite here, suitable alternative employment might be reasonable consideration. We'll talk about that more when we go through redundancy. So there are specific definitions of redundancy, and generally under the Employment Rights Act. And in addition, there are references to redundancy within the Trade Union and Labour Relations Consolidation Act. So the most important thing is here is the legal definition is, first of all, A, the employer has ceased or intends to cease the business to which the employee was employed. B, that the employer ceases the work where the employee was employed. And C, the work to which the employee was engaged is ceasing or diminishing. Yeah, so therefore, work of particular kind or nature has or is to cease or diminish in the place where the person was employed. And before we go on to the next slide here, I will give you the classic example. We have an employee who is employed in Glasgow. Their company covers the whole of Scotland, but the work in Glasgow goes. Yeah. Now, what you could argue is if there is not a requirement or has never been a requirement for them to work in Edinburgh, then you could argue that that position there is redundant in Glasgow. However, if they're generally or they have been employed in Glasgow for a period of time, yet they have in the past worked in different areas throughout Scotland, and there is still the work around in Scotland, you would argue that the work of a particular kind of kind of nature has ceased or diminished in Glasgow. However, it hasn't in the other areas. So therefore, is redundancy happening, and would you need to consider redeployment elsewhere? So again, I'm just going to chuck that in there as a question, but please seek advice, and we're going to cover that more as we move on. So establishing, and this to me is one of the most important things, is establishing the procedure. And the first one, employees would normally deal with the process in the three ways. And the first way is by far the most common, is the ad hoc, we'll call that. There's no formal practice established within the company. And often when the company starts to make people redundant, whether that was in 2010 or whether that's 2021, 2022, that will be different. And that's what we're seeing and we're witnessing. You could also have the larger companies sometimes will have a more formal policy setting out the approach. And that approach could be set via a policy, and that could be incorporated within the contractual terms of the employee. Now, if you have that and you have a formal policy within your business and you have advertised that policy, one could argue that if you did not follow that and you followed an ad hoc approach, it could lead to a breach of contract, because you can't say that you're going to follow a policy, then you don't. So be aware of that. And that then also leads into a formal agreement. And we all have, within the construction industry, we all reference collective terms and conditions. So therefore, your particular employee or employees might come under a formal collectively bargained agreement, whereby a formal agreement explicitly expresses what process you should be following. So what we're saying with this slide is, before you even start, make sure you understand what you're effectively tied into. And again, if you don't know, please ask. Again, generally, I'm not going to go through this and again verbatim on this one. These are really just contents of a redundancy procedure that you would see. And I'm going to be really honest and say that I very rarely see these or have seen these in the last 14 or so years working within this sector, because we generally don't, or we haven't generally, haven't had a need to have a kind of explicit procedure as such as this. Again, I think we can move on from the slide. First thing we need to do, and I'll go through this in a diagram in a wee bit here, is first of all the redundancy pool. What you need to do is, if you are going to look at downsizing your workforce, you need to look at who you're going to do and, you know, effectively what areas you're going to reduce. So therefore, are we going to reduce the level of electricians within the business? Are we going to reduce the level of plumbers? Are we going to reduce the level of joiners, bricklayers, etc., etc.? You would argue that each of those would fit into their own separate economic pool that you would then look at. So therefore, if you were going just to look at joiners and joinery because you didn't have that level of work, that would be your defined pool that you would start to consult with. It would also be wise, if you were going to look at downsizing your company, when even if you're looking at pools, just to tell your employees across the company, and again, it's just conducive to good industrial relations, that you tell everybody what you're doing and why you're doing it. And again, it alleviates undue levels of pressure and stress through within the organization. Okay. Again, the next point here, unless there is a specific policy, you might have a degree of flexibility with regards to your selection pools. So you could have people that are multi-skilled, and therefore, because they're multi-skilled, you might not put them specifically into, for instance, the joinery pool, because they do have the ability or they do have a qualification or competency to do bricklaying or plastering. And therefore, you might say, well, actually, if you are multi-skilled, I'm not going to put you in that pool because you have multi-trade ability. Yeah. Again, that comes again with consider similar or interchangeable work. You know, we do have lots of individuals, especially, and I can probably name some of our Highland and Island members, whereby lots of our journeymen there do similar or interchangeable work, and therefore you've got a greater degree of flexibility. Yeah. So again, just consider that when you're looking at the redundancy pool. Okay. Again, the next thing, and we'll look about that when I'll talk more about that in a moment. You know, we then have to define selection criteria, and this must be objective. It cannot be subjective. And it's okay, very well and good me saying it should be objective. I'm going to smile here because the amount of selection criteria that I look at, whether that's going into tribunal or giving someone a level of employment law advice, I am quite critical here, because albeit the employer is trying to be objective, I very rarely see reasons why they've given them a specific scoring. And I think that's very important, and we can talk about that in a bit. Again, sounds obvious again, but it happens all the time. It should not be down to personal opinion. And again, the person scoring the scoring matrix or doing the selection criterion, have they got reason to score the individual down? Has there been a past history? And if there has, are they the most appropriate person to carry out that scoring matrix with regards to the individual? The last one is I'm asked this question quite a bit. Can I apply last in, first out principle? As in, if an employee's only been with you 18 months or 6 weeks, can I dismiss them before I dismiss the person that's been with us 15, 20 years? There are a couple of things I want to say on this. Is the first one, I'm going to flippantly say, yes, you can apply that last in, first out principle. And quite often employers do it because it's quicker, it's cheaper, because redundancy costs are slightly less. What I'm also going to say is there is a word of warning. Be careful that that does not then apply a discriminatory or discriminatory process, or being discriminate against certain groups, because you could argue that women returners from maternity or women returners to work that haven't had the opportunity to accrue a level of service compared with their male counterpart, you could argue that that would be effectively indirectly discriminate, and therefore be very, very careful when you're applying a LIFO principle if you want to do that. The next thing I'm going to say on that one as well is, more often than not, that some employees who've just joined the business may be a lot more enthusiastic and a lot more competent than some workers that have been within the business a long time, who have potentially become a little bit more complacent than others, and therefore their work ethic might not be the same, and therefore the business might benefit from actually not applying the LIFO principle. But again, check that out. So the choice is yours, but all I'm going to say is be very, very careful how you apply that. So moving on. So first of all, with regards to consultation, you as an employer must seek to give as much warning as practicably possible in the circumstances. So as soon as you know that you might need to downsize your business, you must start to communicate with your employees. Failure to do that might argue that there's something potentially slightly dodgy going on, or that may, with regards to timescales, we're going to talk about in a bit, that may sort of impede the policy or the process that you need to follow. What you should also be doing is, if applicable, and we're seeing this, we do see this within the construction industry, you should also seek to consult with the trade union and agree a selection criteria with them. Even if you don't have a facilities agreement or a local agreement, if your employees, and you know your employees are members of trade unions, and I'm going to say this as someone, as Fiona is as well, someone who's spent many, many years in the industrial relations field, I think it's equitable and reasonable to get the involvement with the trade unions, and more often than not, that you will see that as an added support rather than a hindrance, and I can't stress that enough. Secondly, then the employer must consult with employees with respect to the selection criteria. So we're going to talk about that more. So once you've told your employees that there might be a downsizing exercise, what you need to be doing is telling them, well, how are you going to select those people that you're going to choose for redundancy? And you would need an agreement, or at least consult with them prior to applying a selection criterion as a fait accompli. So be very, very careful here. Again, we'll talk more about this in a bit. I'll show you, we've got a slide on this. Make sure the selection criteria is objective and not subjective. Otherwise, you could be breaking the law. And again, you should also consult in respect to suitable or alternative positions that could be available if people's positions can be made redundant. And the last one here is, if you are going to make 20 or more people redundant within a 90-day period, under Section 188 of the Trade Union and Labour Relations Consolidation Act, you must consult with your employees. And if you do not consult properly, then effectively you could be effectively be fined, or the dismissal could be unfair, and the employee could be awarded a protective award. So again, we'll talk about that more in the next slide. So 20 to 99 redundancies, the consultation must start at least 30 days before any dismissals take effect. My advice to anybody that I'm consulting with, I'll always argue that even if you're going to make less than 20 people redundant within a 90-day period, try and give as much consultation as you possibly can. And I would always argue that at least 2 weeks consultation prior to the first dismissal is fair and reasonable. Notwithstanding that, there will always be circumstances where there will be more of an urgent need because of the finance of the business, but use that as a rarity rather than a common practice. If you're going to make 100 or more redundancies within that period, you must start consultation at least 45 days before any dismissals take effect. Really, really important here, if you are contemplating, even if you don't, because I'm dealing with lots of employers at the moment that were contemplating on making 20 or more, but then actually they're only making 10 or 15 redundant. But if you are contemplating, within the 90-day period, you must complete an HR1 form, which will be sent to the Secretary of State. And this form effectively notifies the local area, the local council, the local economic area, that a business within the area will be making or potentially making a lot of people redundant, and therefore that then alerts the benefits agency and support agencies of that, so economic support can be given. Yeah, and we've seen that within Scottish Enterprise, Skills Development Scotland. The organisations such as that will be aware of these forms, and therefore they can then resource certain areas where that's going to happen. And we saw that, didn't we, in Dundee with the Michelin factory, when they were making lots of people redundant within that. We then had effectively Scottish Enterprise PACE set up further support for the local community, which again was morally very, very important that happened. Okay, and again, the warning is, if you do not consult, then an employment tribunal can award up to 90 days pay for every employee for that breach of the process. Even if they were not made redundant, you know, there could be an argument that they could actually claim for a 90 days pay for the breach. And we have seen that. I'm not going to mention who they were, but we've seen that within some large Scottish construction companies, and we saw that at the last recession and the one before that. And moving on. Okay, I'm not going to underestimate this or undervalue this. I think the most important thing, and this is where I've seen through first-hand experience, this is where things go wrong if we don't apply good communications within our workforce. These are central to the management process when dealing with changes in working practices and procedures. And I think the most important thing here is communication isn't just one way. You are not, consultation means you're consulting with employees about the proposed change, and you are going to listen to the views of employees back. At the end of the day, you do not need to take what the employee says or actually align your strategy with what the employee says. All you as an employer have to do is prove that you listened to that and you had proper justification for making your decision, how you would apply any form of process. So I think that's really, really important here before you make any decision. So moving on then to the next one. What we need to do here is alternatives to dismissal. If you are going to make an employee or their position within the business redundant, then the first thing you must consider is suitable alternative employment. So again, ask them, or if you have any similar or like work, pay, status, terms and conditions, you must offer that to the employee. Yeah, I think that's really, really important. In addition to that, if the employee does not accept that suitable alternative position or alternative work, then they would naturally forfeit their redundancy pay. So there is a benefit there. The next one is, if you do not have any suitable alternative employment, then you must offer, if you have any alternative employment, offer them that. So therefore that could be different work, different pay, different status, different terms and conditions. If the employee accepts that alternative work, they then undertake that alternative work and you agree that, they have a 28-day period of which to accept that. If they're working within that 28 days and they decide they don't like it, then they can come back to you and ask for their redundancy. So therefore, there is a agreed legal trial period. And again, just to reiterate what I've said under suitable alternative, under section 38 and 41, if the employee unreasonably refuses the offer, therefore effectively that will deny them any payment or any redundancy payment under the process. So again, moving on then to the redundancy key steps. First of all, again, I'm just going to whiz through this because I think we've got a diagram after. Identification of business need, notifying and consulting with your employees. You would then select via a scoring matrix or other means. You would then further consult. You would then make a business decision, and you would then notify individuals. And this is the important thing, is you would have to bring the individuals into a formal meeting, make a decision, and then you would have to offer the employee the right to appeal against the decision. So we're moving then on to the next screen, and I think this gives it in further detail. So again, moving through this very, very quickly, and I'm moving into the preparation. Before you even meet or you meet with your employees, prepare, set the time frame. You know, when do you want the first employees to go? And that would very much depend on the volume of employees that you would need to reduce your business by. You would look looking at a criteria, and you would look at the selection pools that were at risk. The first thing you would then do is you would meet with your employees, whether that would be through selected representatives or individual consultation and with the trade unions, and you would talk to your employees at what you're proposing. But what you would say at that point is, we haven't made a decision, we haven't got the exact numbers, we are just looking at what we want or what we potentially need to do, and you're then asking the employees to go away and think about what you've just said to them. You would then arrange another meeting, which is in 3, and you would consider any feedback from the employees with regards to either the selection criterion, or it could be a case of other ideas whereby the employees might come back and say, we're all prepared to take a 50% pay cut. Normally or generally that's highly unlikely. However, if that is offered, you might wish to consider that and agree with the employees that no one then will be dismissed for a period of time until we can sort of ride the storm out, as they say. So you would consider what the employees said. You would then, after that meeting, you would then write to the employees formalizing the selection criterion and the pools. You would then carry out the selection criteria, and then after you've done that, you would then invite those people at risk to a meeting, allowing them to be accompanied with a companion, and then you would formally give them the decision. But before that meeting, you would have given them their scoring, so they've got a right to see that before their meeting. After the meeting, you would then you'd confirm the decision, and you would give them the right to appeal. Yeah. And again, you'll see through in the bottom of the diagram that you would be offering them, you'd be considering the suitable alternative or alternative employment, give them the right to appeal. You would then need to make a decision as well. Would you want them to work their notice, or would you pay them in lieu of notice? So effectively, if you wanted them to work their notice, they would naturally work their notice, and they would leave after that notice period. Lots of employers, however, do not want the employee to work the notice because of potential disruption. And on that basis, what could the employer do? The employer could either put the employee with their agreement, or through contractual agreement, put them on gardening leave, or alternatively pay in lieu of notice. Yeah. My advice here with regards to this is, if you dismiss the employee and you pay them in lieu of notice, they're not working, for instance, their 12 weeks notice that you had to give them, then if the work then picks up within that 12-week period, have you potentially dismissed them prematurely, and would they have a claim against you as a company? So therefore, always a consideration here is, would I want to just put them on garden leave, so therefore they're not required to come into work, they're not required to do anything or work during that period, but if you have an upsurge in work, you have the ability to retract their notice during that period. Again, the question is yours. So if we then move on then to the next slide on the appeal process, what you would do is, you would with any form of appeal, you would obviously appoint a hearing officer, you'd write to the employee, you set a hearing date, you would gather the evidence, you would hear the appeal, and then you would give them the decision whether you would uphold the dismissal or not. And again, I don't intend to go into this in any further detail. Quite simplistically, this slide is showing the ACAS code of practice with regard to what you need to do. Again, if you are in any doubt or any concern, please speak to an HR advisor or professional with regards to this. Moving on to the next slide. This is an example of a selection criterion, a typical selection criterion that we would use. Again, it is very much a sample. Most important thing here is making sure that the criteria, and generally ones that we use are far more detailed than this, but make sure all of these areas are effectively objective and not subjective. What people would generally do is they would give a scoring 1 to 10. So when you are in the box of below average, the individual could score between 1 and 4. Within average, you could score 5, or 6. Within good, it could be 7 to 8, and excellent could be 9 and 10. Over the last 3 or 4 months, I've seen a few, in a way, call it probably the armadillo complex. The industry likes to be very tough on the outside, but when it comes to scoring people, they like to be overtly nice. So therefore, what I have seen is companies score everybody a 10 as excellent and then work back. And therefore, when, what we will see when they're doing that is everybody's scores will be crunched up and they will be literally 1 or 2 apart. My advice here is, if you are scoring employees, start everybody on 5 as the average, and then go up or down depending on whether they're good or excellent or they're going below average. Most importantly is, once you've given them a score as well, give them a reason why you've given them a score. Yeah, I've given you a score because actually your attitude wasn't good on that last job. You were asked to do something, you didn't cooperate, and you were just being downright obstructive. Yeah, and you are giving explicit examples. Yeah, or you didn't cooperate and you were given an informal warning. That's or you could give an example whereby you were incredibly good, you used your initiative on that project, and that's why I scored you a 10. And this is the kind of evidence that we generally lack, and this is the evidence that we need when we're holding an appeal, or whether we're going to a tribunal, is more explicit evidence. And by giving that explicit evidence, it becomes very objective, or we could argue that it is objective. So moving on, next slide. Very quickly go through calculating redundancy pay. Now, on the government websites, there are fantastic calculators now where you can do that. But very basically, up to the age of 22, an employee would get half a week's pay for each year of employment if they have at least 2 years of continuous service. And I think that's important. Anybody under 2 years they're not entitled to redundancy pay. Over the age of 22, the employee gets 1 week's pay for each year of employment between the ages of 22 and 40. And then over 41, 1.5 weeks pay for each year of employment. And therefore, a maximum of 20 years employment can be taken into account. So if you've had an employee with you from an apprentice and they're leaving you effectively in their 40s, you might need to effectively apply different methodologies of calculation there, and that's what that's showing. My advice here is go onto the government websites. We have created a calculator app that I can make available, and that's quite a good process of calculating redundancy pay. Bear in mind also there's a statutory maximum limit to a week's pay, and for lots of journeymen now that will impede the volume of pay that they would get in a redundancy, and that's currently capped at £538 a week. That is changed every year by the Chancellor during the budget, and that generally goes up every year in line with inflation. And really, really important here is, don't forget notice pay. And this is really important. An employee would be entitled to 1 week's, on top of their redundancy, 1 week's notice pay for every completed year of service, up to a maximum of 12 weeks. I've also put in here that it also depends on their contracts of employment. So if you've got an employee whose contract of employment says, after 5 years service, you will be entitled to 6 months notice, then you will have to pay the 6 months notice. So really, it's whichever is the greater value you'll have to pay. So moving on. So to conclude here, before we go on to the key actions here, all too often we are witnessing as HR and professionals here, or employees are being automatically invited in and told that they're being made redundant without any potential process because of the employer's sheer panic that this needs to be done as a fait accompli. And this does often lead to unfair dismissals. Yeah. Any business breaching the process does so at their own peril. So I do advise, again, get support here. Redundancy is a matter of good and effective communication. And what I mean by that is, in my experience, is we never like to be told the truth when it comes to things like we might lose our job. But at the end of the day, we might not like what we're hearing, but once we've heard it, we will fully respect what's happened. And I think that's really, really important to understand here. Okay, and that then goes on to, as I said here, it's proven that employees who have been consulted with properly understand the need and are therefore less likely to claim that they're unfairly dismissed. And that's really, really important. And the last thing on this slide is, and again, not just saying this, is take the time. If it takes you a week longer, it might be a week's extra pay. But if that avoids a £10,000 fine on a redundancy, then please take that extra time. Yeah. So look at the long or the bigger picture rather than the shorter picture. Okay. So moving on then to the final slide before questions. We are entering to unprecedented times, and you most probably will never have managed this issue before, especially with regards to COVID. Albeit you might have restructured in the past, but we're dealing with an unprecedented times. Whether you're an MD, director, or HR practitioner, everybody wants answers, yet we are dealing with levels of uncertainty. Yeah, and I think that's important. Don't beat yourselves up if you don't know the answer. And I think I can talk for all the panelists here. We're always asked questions that sometimes we don't know the answer. And I think the most important thing here is that if you don't know the answer, someone will know it or you can find it out. So please, please ask. Okay. During these times, we are obviously asking employees to accept a variation to their contract with less pay. And again, if they don't agree to it and you apply it, you know, the fine could be costly. So again, make sure that whatever you do, back it up in writing, make sure you are getting agreement. Just because an employee nods or doesn't answer you doesn't mean they can agree to the variation in silence. You have to do that explicitly and it has to be expressed in writing. Okay. Despite COVID, again, not to avoid this either, discipline and grievance issues still exist and they do need to be dealt with. You can't just leave it and deal with it in another year's time. You've got to deal with it. And again, I am witnessing disciplinary hearings being held on Zoom, on Microsoft Teams, because of social distancing issues. That still can be done. Again, if you're contemplating changes, be aware of the timescales. Do you need to start that consultation now, or do you need to start it next week? And the last thing I'm going to say is please, please, please seek advice if there's anything you need to seek support on. So I'm going to hand you back to Fiona, and thank you very much for your attention.
Thank you, Vaughan. I'm having a technical issue at the moment. There we go. Thank you again, Vaughan. That's the presentation complete, everyone. We don't seem to have any questions in the Q&A, but I have a couple of questions that my own team receive now and again, if not quite often. So I'm going to use them. And if you do feel like asking a question, just put it in and we'll pick it up. Does that sound okay, Pete and Vaughan?
Yep.
First question is, when calculating redundancy pay, I know I should base the value of a week's redundancy pay on an average of the pay received in the 12 weeks immediately prior to the day I make people redundant. My employee has been on furlough for all of these 12 weeks, receiving 80% of their usual pay. Should I use this 12-week reference period to calculate the redundancy pay?
a very, do you want me to answer that one, Fiona? You happy
Yes,
with that? Okay,
absolutely.
that is quite an interesting one, and we get asked that quite a lot. Now, it is a very grey area, and the reason it's a grey area is in the absence of a common law principle with regards to this. So again, we're going to see more and more of this through employment tribunals moving forward. The argument could be is the employee has accepted the variation of contract for the last 12 weeks, and therefore they've accepted the 80%, and therefore that is effectively in law an average, okay? The advice within construction generally is if they were only earning that 80%, the advice that we are seeing is don't use those 12 weeks, go back the 12 weeks that they were earning prior to that furlough period. At least then we are showing a level of equitability and moral standing, okay? But it is arguable, and I would turn around and say, before you do that, or if you've got any strong objection to that, please ask advice before you do it, and we would have a look at your contractual terms and what you've actually agreed with the employees prior to going on furlough.
Yeah, and it's particularly important when people are working longer hours and shift patterns, and just to take that into account and make sure that you're on the right side of the law and good practice. This next question is on selection criteria, and it's a question around of who should be involved in completing the selection matrix, the exercise. And that's especially when, as in our industry, a number of people work on various contracts with various line managers or supervisors. And so should it be somebody from head office? Should it be the line managers? Should it be a group of people?
I'm going to probably answer that. I'm going to try and answer this very, very quickly. I would argue straight away it should be the people within a reference period whom the employee has worked with and who can evidence or has evidence or experience of their abilities, especially within the selection criterion. So a very recent case, obviously not mentioning names, rank or pack drill here, is it is often, 3 or 4 people that they have worked with, yeah? And therefore, from there, you could then apply a level of weighting. What I would advise you do not do is you do not have people to score the individual who have not worked with the individual directly. You would have to evidence that through prime example. Otherwise, the scoring could be questioned. Does that answer the question?
I think so. So the final question is a question we are asked an awful lot is, at what point can I change my mind about making a redundancy, especially if new work comes in and the business's financial outlook improves?
Okay, I suppose in a way it's like the last minute reprieve, isn't it? If the employee, one could argue in legal terms that the employer has till 4:59 if the employee is finishing at 5 o'clock on the last day to retract the notice if there is work available. Yeah, that would be fair and equitable. Be careful though. And the reason I'm saying that is the employee, depending on how you've treated the employee, and it goes back to that slide that I shared at the very beginning, constructive dismissal. Yeah, if you have treated the employee believes that you've treated them abysmally and you effectively are playing with them with regard to retracting that notice at 4:59, they could leave anyway and claim that they were constructively dismissed because of your behavior. So to answer your question, Fiona, is you can retract the notice up to the last minute or the last day before they're going to leave, and that would be absolutely fine. Yeah. However, if you do that, but you knew that you had work going forward, be careful that the employee doesn't use that against you and say, I'm leaving anyway, because you had no intention to pay me my redundancy anyway, and all you're doing is playing with me, and I'm now leaving and claiming that I was constructively dismissed as a result of your repudiatory conduct. So again, that's quite an interesting one.
Yes. So we've had one piece of chat through the Q&A, and it's asking about the PowerPoint. And it is our intention, everyone, to put the PowerPoint onto the website after this webinar is finished. So it will be there. Just go on to CICD forum Our time is up. Thank you so very much for joining us today. I hope we have been able to add some clarity to the difficult and complex processes of organisational change and redundancy. And hopefully we have been able to give you some confidence that the law and the process will guide you through these matters. Just remember, if you're ever in any doubt, talk to a specialist, be that the employment teams in your federations and associations or an employment lawyer. I would like to thank Vaughan and Pete on your behalf. It's been a most interesting and formative session. And before we go, just let me remind you to take a look at our website. Please follow us on Twitter, LinkedIn and Facebook. And thank you once again for joining us. We hope to see you again very soon. Bye-bye for now. Keep optimistic, always follow good practice and stay safe.
Thank you.